Hi, everyone. Welcome back to the seventh session of Morrison Foerster's and Nucleate's Advanced Topics in Patent Law course. We hope that you're finding these sessions helpful and look forward to continuing these discussions over the next few weeks. Today's session, we will focus on life sciences, AI, and machine learning, patent drafting, and IP strategies. And this discussion will be led by my colleagues, Anna Yuan and Nguyen. Keep in mind to please use the Q&A feature on the Zoom screen if you have any questions. We'll do our best to get your questions answered. Many of you have reached out to us for office hours. Thank you for doing so. We continue to have office hours, so for those of you who have questions, want to speak with an attorney or agent at MoFo about your interest in IP law, or forming a company or something patentable, whatever you want to talk about, we're happy to do so. Please send us an email and let us know the nature of your questions. With that, I introduce Jean and Anna to take it from here. Thank you.
Thank you, Mike. Hi, everyone. My name is Anna Yuan. And as Mike mentioned, today my colleague Nguyen and I will be discussing patenting AI technologies and some special considerations for life sciences companies that are seeking patent protection in this space. Before we start, I just wanted to briefly introduce myself and my practice. So I'm a senior associate at MoFo. I've been at MoFo for about 8 years, and my practice primarily focuses on formulating IP strategies and developing patent portfolios for software-based technologies. I work with clients of all sizes. I've worked with a lot of startup companies to draft their first patent application or their first patent portfolio. And I've also worked with larger companies on the scale of Apple and Slack to manage their global patent portfolios. So I do have a technical background. I studied computer engineering with minors in mathematics and computer science back in college. And after college, I worked at Microsoft in Seattle as a program manager for a couple of years before going to law school. I went to law school at Harvard Law School, and I've been working at MoFo ever since I graduated from law school. So when I first started at MoFo, most of the clients I worked with are software or technology companies. In more recent years, software is being used more and more by life sciences companies and medical device companies to develop new products or improve their existing processes. So I've worked with a lot of life sciences companies to help them develop their IP strategies and their patent portfolio. In addition to that, I also work with a lot of investors that are looking to invest in startup companies in this space. For example, if a client like SoftBank is interested in investing in a startup, I may be involved in conducting the IP due diligence on the startup companies' IP strategies and patent portfolios to see if there are any issues or red flags that may impact the investment decision. So that's a quick overview of myself and my practice. Now I'll turn it over to Jean, who will also be providing an introduction.
Thank you, Anna. Hi, everybody. My name is Nguyen. I am also an associate in the patent prosecution group. I work pretty closely with Anna, both on software and also I do a bit of hardware, helping companies of all different sizes, startups, big companies, individual inventors as well, trying to obtain robust IP portfolios to protect their products and their innovations. I do a lot of work in artificial intelligence, machine learning, so I'm very happy to be here. And similar to Anna, I've been at MoFo for almost 10 years now, 4 of it of which I've been an attorney, and then the other 6, I was a patent agent.
Great, thanks, Jean. Can we go to the next slide? Okay, so in terms of agenda, I'll start by just talking about the AI filing trends in the past couple of years. I'll talk about what AI technologies can be patented, as well as IP strategies for AI, and that includes, kind of thinking through the pros and cons of patent versus trade secret versus copyright. And then Jean will talk about AI basics. She'll talk about patentability of AI in the United States. And she'll talk about some really interesting case studies for patenting machine learning and AI for life sciences companies. Next slide. Okay, so the figure that you're looking at here is a figure from the World Intellectual Property Organization, and it shows the number of patent families related to various AI fields that have been filed all the way from 1981 until 2016. And the next slide, I'll have some even more recent data. But as some of you may know, AI or machine learning have arguably been around for a long time. Arguably they've been around since the 50s. And this figure here shows that patent families related to AI application fields emerged pretty early on in the 1990s. But as you can see, the trend the number of filings have been pretty flat until more recent years, especially around 2011. That's when there has been an exponential growth in the number of patent filings in various AI technologies. In addition to seeing this really huge upsurge in just the sheer number of patents being filed in the space, we're also seeing a shift in what is being patented. In the earlier days, a lot of the patents are more focused on, the pure theories of AI or AI models. But in more recent years, the patent filings have been more focused on the practical applications of machine learning and artificial intelligence in general to solve a specific problem. So as example here, one of the fastest growing areas is transportation, where AI, specifically computer vision, has been used to operate autonomous vehicles and to monitor road conditions. And as another example, life sciences and medical sciences is another really, really fast growing field. And this is what our presentation will be focusing on today. So this, can you go to the next slide, Nora? Okay, so the figure that you saw just now shows the trend up until 2016. And this figure shows kind of the more recent data from 2017 to 2020 for patent filing trends in the US. And as you can see here, the growth in the past couple of years have been even more aggressive. We've seen, approximately 8x increase in AI patents from 2017 to 2020. And we're also seeing a higher percentage of non-US applicants, companies or individuals that are seeking patent protection in the AI space. So all in all, this just shows that the AI patent space is getting very crowded very quickly in the past couple of years, and AI patents have really been shown a lot of strategic values for various companies. Next slide, please. Okay, so what can be patented? On a high level, there are two buckets of AI inventions. The first bucket is really the application of known AI or machine learning to specific fields and sectors. So in this first bucket of AI inventions, the inventors may not have invented, some groundbreaking machine learning algorithms, but rather they figured out a novel way to apply a known machine learning algorithm to solve a very specific problem. So an example of that would be, achieving a new, better outcome using machine learning in autonomous driving. Another example would be using machine learning in a novel way for drug discovery or for diagnostics. The second bucket of AI inventions are directed to new AI models and algorithms. And among the two buckets, the first buckets of inventions tend to be higher value because it is more likely to detect infringement of these patents, and the claims we can draft to cover these AI inventions can be pretty broad. So just as an example, if you have invented a novel way to use machine learning to, for example, develop a drug, and if your competitor is doing something similar, it is probably going to be pretty easy for you to figure out whether the patent is being infringed by your competitor just by looking at your competitor's website, looking at their manuals, looking at their advertisement, to just figure out whether it is whether the patent is potentially infringed. In comparison, if you're filing an application on a brand new AI algorithm, chances are you're probably going to get a very narrow and specific claim that really covers the specific design and implementation of the machine learning model. And those kind of details are really harder to detect in your competitor's product because they tend to be more under the hood. And that is why the first bucket of AI inventions, which are directed to applying known machine learning to solve a specific problem, tend to be higher value. Next slide, please. Okay, so before diving more into the patent issues, I just wanted to take a step back and note that IP is not just in the form of patent. It could also be in the form of trade secret and copyright. So when you're thinking about protecting your IP, you really want to think holistically about your IP strategies. And your IP strategies may include a combination of patent, trade secret, and copyright. So I'll just quickly go through kind of the differences, high-level differences among these. Patents on a high level protect new, useful, and non-obvious ideas. And some examples of AI patents could be directed to an AI-based algorithm, an AI-based device, a drug that's developed by AI or discovered by AI, or the computer hardware that is designed to run AI machine learning algorithms. In order to get a patent, you need to file a patent application. And so, this does involve, working with a patent attorney to figure out, what's the best way to, prepare your patent application, prepare the patent application, figuring out what jurisdictions you're interested in, and filing a patent application in each of the jurisdictions you are interested in. Trade secrets on a high level protect confidential information that provides a competitive advantage due to its secrecy. So trade secret doesn't necessarily only cover ideas. It could also cover things like a customer list, a recipe. For example, the Coca-Cola formula is a famous example of a trade secret. So you can protect as trade secret software code and any other aspect of AI that can be kept confidential. And in order to, get trade secret protection, you need to make a reasonable effort to maintain secrecy. For example, by implementing trade secret policy to make sure, your software code is properly protected and the access to the software code is restricted. Copyright on a high level protects original textual works and visual or artistic expressions. So it's really important to recognize that copyright only covers expressions, not the ideas. So for example, you could potentially use copyright to protect software code or graphical user interfaces. But this really only covers the scenario where somebody literally copy pasted your software code and compiled it and put it in their device. If your competitor is smarter and they didn't just literally steal your code, but rather they, kind of reverse engineered your idea and wrote their own code, then copyright would not be sufficient to give you protection in that scenario. Next slide. Okay, so what are some of the advantages of having patents over trade secret or copyright? So the big take-home message is that patents are especially important in competitive fields such as AI for a couple of reasons. Number one, trade secret cannot protect against independent development. What this means is, for example, today, if you invented, this unique way of using AI to solve a particular problem, and tomorrow somebody on the other side of the world independently came up with the same idea. If you don't have a patent and you're just keeping what you're doing as a secret, there's nothing you can do to exclude that other person from entering the market. On the other hand, if you do have a patent, it doesn't really matter how they thought of the idea, whether independently or reverse engineering what you're doing. You can potentially assert the patent against them to exclude them from entering the same market. So that also covers the second reason I have here, which is trade secret cannot protect against reverse engineering. And the third reason is that trade secret can be impractical to enforce. And this is especially true for software technologies, because as you know, it's pretty common for software engineers to move around companies. And so there just may not be very, it may just not be very practical to make sure that they don't take the trade secret with them, and that trade secret would not be misappropriated by their future companies. The fourth reason is that trade secret may be unavailable for easily detectable technologies. So this gets at the idea that many important aspects of software cannot actually be kept as trade secret. For example, if you have designed and implemented a software that enabled a new user experience or a new use case, those aspects of the software are inherently end user facing. You can't make money by hiding your user experience or your user interfaces, right? So there's just literally no way for you to keep them as trade secret. And so to the extent that you do want to preclude other people from providing a similar user experience or use case, then patent is the way to go, because trade secret is simply not available in that scenario. Copyright protects only copying of data. We kind of already talked about that. Patents are limited term monopolies that really allow you to exclude other people from making, selling, manufacturing the invention. And the last point here is that patents have defensive value, and this is a really important consideration. So a lot of companies may think, I don't need patent because I never plan to assert any patents against my competitors. I just want to do my own thing and work on my own product. That is not always a good idea, because chances are, as you become a very important player in the market, your competitors may try to assert their patents against you. So you may be getting cease and desist letters from your competitors. And in the cease and desist letters, they will list patents of theirs that they think you are infringing. So we've dealt with a lot of situations like this, and typically one of the most important considerations here is, do you have your own patents that are very robust that potentially can be read onto your competitor's product? If you do have a strong patent portfolio that could be relevant to your competitor, then you're in a much better shape, because you can write back and tell your competitor, I don't infringe. First of all, I don't infringe your patents, and also, you may be infringing my patents. And what follows is potentially a negotiation, and potentially you two may decide to enter a cross-licensing agreement, or you decide to just walk away. But the important thing is you do have bargaining chips in this negotiation, which is your patent portfolio. If you get the letter and you have no patent portfolios and no bargaining chips, then you're in a much weaker position in this negotiation. So that's why patents have defensive value. It doesn't just have offensive value. It's not just valuable in case you want to sue somebody. It's also valuable when somebody wants to sue you. So overall, we do recommend a hybrid approach. We recognize that it's just impractical for a company to file patent applications covering everything they're doing. But at the same time, it's not a good idea to keep everything you're doing as a trade secret. And so it's really important to work with your patent attorney to really figure out a comprehensive IP strategy that could involve a combination of patents, trade secret, and copyright. And so, for example, you could consider filing patent applications on broader ideas, a broader idea of using machine learning in a novel way to solve a specific problem. You can file a patent application on the high-level algorithm, the high-level flows and logics of the algorithm. But at the same time, you can keep the low-level implementation details and the fine-tuning and optimization details as trade secret. This way, you can prevent somebody from reproducing your invention to the same level of success, even if they do see your patent application.
Hey, Anna?
Yep.
That's Mike. We've got a couple of questions. So first is, if we have IP protection on the software, do we also need copyright registration? And then kind of a follow-on to that, if indeed you want to protect the copyright, how do you do that?
Yeah. So we can talk more offline, but generally, generally patent is just much more of a valuable venue to protect software, because again, it covers the idea rather than just the expression. With copyright, you could register with the government, but the registration is optional, but it does get you specific benefits. So we can talk more offline, but generally, the recommendation is you do want to file patent applications on your software technology, and you should not only rely on copyright for software patent protection, for software protection.
Then there's a follow-up question related to Google, and they're just wondering if their search algorithms are patented, and if so, aren't they expired? And I would answer that more broadly in the sense of, what do you do when there are old, algorithms that are protected? What do people do when they expire?
Yeah, so that's a good question. And generally for software, the software patents are generally most valuable in the first, couple of years. Patents do have a 20-year term, but this is where software and life sciences kind of diverge, in that a lot of life sciences patents are valuable up until the last moment. And any additional day in your patent term could mean a ton of revenue. Whereas, for software patents, the value kind of like goes down just because of how fast, software evolves. And so it really is the most valuable in, the earlier part of the 20 years as opposed to later. Okay, if we don't have any further questions, I will now turn it to Jean, who will be providing some AI basics.
Thank you, Anna. Okay, so let's quickly talk about AI basics. AI encompasses any computer program that is able to do tasks, solve problems, that usually it requires human intelligence. So some examples just to give you: visual perception, speech recognition, decision-making, word translation. Those are all within the scope of AI. And then going to a subset of AI is machine learning. So machine learning is an application of AI that trains a model or a set of algorithms to parse data. And then what the machine learning model does is it applies what it's learned to make informed decisions. And then finally, one level deeper, shown in green, is deep learning. So deep learning is really, it's algorithms and layers structured to create this artificial neural network. You'll see that term a lot, where the system can learn and make intelligence decisions on its own. Next slide. So this slide shows the flow starting from the architecture of, and in this example, it's a machine learning model, training it and then applying it. On the left, you can see you start with an untrained model, untrained network model, where the model may be selected based on the configuration, such as what is its input, what is its output, and what are the layers that form the neural network. We then train the neural network, shown in the orange box, to learn a new capability, like how do you solve a specific problem? And how it's trained is by providing it with this training data set and allowing the model to learn from the training data set. So to give you an example, as shown on the slide, a specific problem may be determining whether an image has a cat in it. The training data set provided to the model may comprise images that have cats and some images that don't. Then the result from the training is a trained model that now has this new capability, being able to discriminate between images that have cats and images that don't. So then the trained model can put this into use into the inference stage, shown on the right, where the capabilities is then applied to new data. So in this example, back to the cat, the new data may be a set of images with unknown information as to which one comprises cats. And the output of a model will then be, for example, image 1 has a cat, image 2 does not, and etc. Next slide. So there are 4 main patentability hurdles that you need to overcome, and I believe a lot of these have been discussed in the course. The first one is patent eligibility, and I'll just quickly go over each one of these. And the question there is whether the claimed invention is eligible for patent protection. Then there's novelty. The inquiry there is, what is the claimed invention and is it new? Finally, there's obviousness as the third hurdle, where the question is, is the claim invention obvious over the prior art? And then following is written description. So in drafting your patent applications, you really need to be sure that the claimed invention is adequately described in the application. Next slide. Talking a little bit more about the first one, patent eligibility. So when it comes to artificial intelligence and machine learning inventions, the most common patent eligibility challenge relates to abstract ideas. Basically, is the invention an abstract idea without significantly more? That's the hurdle, and that's the question you need to be faced with when it comes to patenting. So it can be anything from mathematical concepts, certain methods of organizing human activity, mental processes. One example is a claim reciting steps or elements to carry out a technical purpose based on the output of a machine learning model or an AI model. So for example, operating robots, administering treatment, graphical user interfaces, these could all be considered abstract ideas. And I'll provide a bit more examples in just a bit. Next slide. Okay, so let's turn to one example provided by the USPTO. So there's been a lot of challenges when it comes to patenting software and the kind of the hurdles that these practitioners have to face when it comes to abstract ideas. So as a result, the USPTO has provided some examples that everybody, you can follow when you're trying to overcome patent rejections from examiners. Here is example number 39. It's directed to a computer implemented method of training a neural network. And the claim, as you see here in the bolded words, it comprises 6 steps. It's collecting a set of digital facial images, applying one or more transformations, creating a first training set, creating a second training set, and then training the neural network. So in this example that's provided by the USPTO, the Patent Office said that this claim is patent eligible because two reasons. One, there's no mathematical concepts recited in the claims. And then also the steps being performed are not practically performed in the human mind. So in other words, it passes the muster required for subject matter eligibility. Next slide. So one way to think about eligibility for artificial intelligence and machine learning inventions is to ask whether the claim as a whole is directed to or integrates a practical applications. And here are some more specific examples of practical applications. The one I mentioned earlier is one. Another example are features related to improving the functioning of a computer or to another technical field. So for example, if you have a unique data structure, a unique data pre-processing, a combination of steps that lead to improving the computer and how it functions. These may be considered abstract ideas, but they may also still be patent eligible because it is a type of improvement that's being offered by the invention. So for those types of inventions, when it comes to drafting the application, you really want to frame the claims as kind of a technical solution to a technical problem approach. And in that, you want to make sure that your claims really do recite the technical solution and have it be tied to the technical problem. As another example, there's also interactions with hardware. That's another way to help overcome some patent eligibility challenges. So for example, tie the software to the hardware, hardware acceleration, AI chips. It just generally may be helpful to make a particular machine or manufacturer become an integral part to the claim. Next slide. Okay, moving to the second part, let's talk a little bit about novelty and non-obviousness. Here are some wrong and right ways to think about an AI invention, especially when it comes to novelty and non-obviousness. And just generally, these are things you want to think about kind of in the earlier stages as you're drafting your patent application. So wrong ways. First one is, for example, the invention is just an application of paper X. Another way to kind of think about it in a wrong way is the invention just leverages open source software Y. So when you frame the invention in that manner, it looks pretty simple and maybe not so novel. You really want to recite and emphasize points of novelty in your application. And you also want to convey any differences that your invention has over the prior art. Just generally, basic machine learning is not new. So you really have to kind of tease out what is the important part and what is the innovative parts over what's out there. So as a result, your inquiry really should be, what is the technical problem and what is the technical solution? So that's helpful both in the US and other jurisdictions like Europe. And here's some examples provided on the bottom of this slide. Some of the right ways to think about it is this a novel way to leverage AI to solve a new problem? Another way to think about it, what are the technical challenges you encountered? And, that goes back to the technical problem inquiry. And then how do I, overcome these technical challenges? Okay, next slide. So, as part of some examples are always helpful, at least I think they are. We just want to talk about different claim types for AI inventions. Anna talked a bit about the applications and the two broad types, and we'll provide here an example for each type. So the first one is back to the application types. It covers using output data for a specific purpose. There's also the training type, training claims that cover how to train the machine learning model. It could be unique training process. It could be the configuration of the parameters. It could also be, the termination conditions. How do you stop training the machine learning models such that it's able to do what you've trained it to do? And then lastly, it'll be architecture claims. So these cover the structure model. This is everything from, the unique topology of your neural network or the interaction between multiple models. And I'll note, although this slide shows 3 types of claims for AI inventions. There are other types of claims. So there, there's pre-processing of training data. There's the hardware that I touched upon briefly earlier. There's also the hybrid claiming. You can create claims that are kind of combination application and training, et cetera. But just generally, regardless of the type of claim that you have, there are a few kind of claim drafting considerations during the process. Some things to keep in mind, keep commercialization in mind. You want to make sure your claims cover different ways to commercialize the technology. Other things to think about is, avoid some sort of multi-infringement issues. So for example, if you have one company that does the training and you have another company that's applying the machine learning model, you want to keep your claims a little bit separate. So that you don't have this claim that covers both, and all of a sudden you've got an issue with two parties infringing. Some other things to think about is avoid claiming black boxes. So if you don't, if you have a machine learning model and it's receiving the input and it's providing an output, you want to try to include the details of how did you go from input to output. And then other drafting considerations, maximize detectability. Anna talked about that earlier. We really want to be able to detect what's going on, kind of, if you can figure out what's under the hood, then that's always a good thing, right, from a detectability standpoint. And then lastly, you want to make sure that the claims are supported by an enabling description. Okay, next slide. So let's start with the application type claims. Next slide. So for application type claims, there are a few things you should consider asking yourself and or explaining in the specification. And here are a few questions. So what does the invention do? How does the invention do it? What are the inputs and outputs of the AI or the machine learning model? What is the function of the system? And then back to the technical problem, technical solution. What is the problem and how is it solved? So in drafting your application and drafting your claims, just kind of go through this. Maybe it's a mental checklist just to really tease out kind of answers to all these questions. And then in terms of whether to draft claims that are directed to the application, there's also some considerations. So for example, subject matter eligibility. So subject matter eligibility for application type claims, they may become easier just because you've got that practical application that's recited in the claims. In addition to things to consider are the scope. Sometimes the scope of the claims can be broader, as Anna mentioned earlier, but sometimes it can be narrower. So it really just depends on how you frame the claim. So if you make the claim, be only one specific type of model to cover one very specific type of application, maybe that's good to have it narrow because it helps you overcome the prior art, but maybe it's bad because you no longer have a patent that is, that covers more than just that one specific application. Okay, so next slide. And here's an example for a patent that's an application type claim. So this one it's claim 16. It's patent directed to methods for assessing the status of a condition in a subject and a treatment recommendation. So as you can see from the claim here, the method comprises several steps, one being a step involving performing analysis of a biological data sample from a subject. And then, a step involves applying a neural network to determine whether the biological sample contains cells indicative of the status of the condition of a subject. And so if you look at it from the perspective of the application, this claim, it really just covers the application of assessing the condition of a subject. However, it is pretty broad because it talks about the biological sample containing cells indicative of the status of the condition of subject. So just generally, right, there are many cells that can be indicative of many different statuses of a subject, such as a human. So this is both broad and narrow. And, what you could do is frame this claim so that it's broad in this sense, as shown here, and then, take the dependent claims in a manner that you start to be more specific to, for example, the cells that you're detecting or the conditions that you're trying to figure out or that are related to the cells. Next slide. Okay, so let's go over some quick example of a training claim. And next slide. So for training claims, there are a few things, again, to ask yourself and or consider explaining in the specification. How is the data collected? How are the results predicted? How are the model parameters updated? What is the underlying training data set? And, this goes back to kind of the CAT example provided earlier. Just think about what is the input, what is the output, and what is going on, from input to output. Here also some considerations when deciding whether to draft training type claims is subject matter eligibility. Earlier, we provided example number 39. Just keep that in your back pocket. That is an example about training a machine learning model. Make sure that the specification describes at length how the claimed invention solves problems related to training, such as, is less training data required? That's always a benefit. Are you able to train the machine learning model with different data? So for example, labeled or unlabeled. And also, can you train the model faster? That's another benefit. So really, to the extent that you can highlight that kind of practical application, practical benefit in the application. And then one thing to consider is whether infringement is easier or harder. And really, it's all about who's training the model and when is it happening? Is it happening under the hood, or is it happening, kind of in real time? So it's something really to consider. And then also, it's not listed here, but the divided infringement example that I gave you earlier, right? You've got, company A is applying the application, whereas company B may be training the application. So if one company is training the model and another company is using the trained model, consider separating out your claims so that you don't have one claim covering both.
Hey, Jean?
Yes.
We got a couple questions.
Sure.
So if you want to patent a process that includes using commercial or public software that you don't own, let's say it's Excel, Python, how do you handle that?
Yeah, so I would consider making it part of more of a passive recitation, right? So you're not really claiming this open source software, but you're more so using the software for your application.
So maybe disclose it in the patent application is one way to do it.
Yes, yes.
Yeah.
Yeah, and to the extent that you can provide examples of, multiple different ways. So not only like Excel, for example, you have another, I don't know, spreadsheet manufacturer or software, provide as many examples as you can in the specification.
Yeah, so you're not limited to Excel because somebody will just go buy something else and use it.
You're good, yeah.
How about inactive where-in clauses? Can you explain those?
Yeah, so that was just what I was talking about. The inactive wherein clauses is more of a passive recitation, right? So for example, wherein, going back to your Excel example, wherein the software uses Excel, versus if you say, the method of creating an Excel spreadsheet, for example, sometimes your actual invention may not be creating the software, but maybe using it instead. So that's where the inactive wherein clauses come into play.
There's another question that kind of ties to the one prior to this, which is sort of if you want to patent a process and you're using publicly available data, you're crunching those numbers. Any issues there?
Yeah, so if the data is already created, you should be able to use it also wherein inactive clauses, right? Wherein the data is X rather than, creating data X. It should be okay as long as you try to generalize it to the extent that you can in the claims. And then back to the specification, provide examples. Examples are always helpful.
Thank
you. Okay. So moving on to the next slide. Another example training claim here. So this is, a patent that's training a neural network using an augmented training data set. Similarly here, the claim just covers training the machine learning model to recognize a target object. That target object could be, for example, a cell nucleus in an image. So generally, you'll see it's receiving input, right? So it's not generating the input. This is also, if you weren't actually generating the data set, but you're receiving as input a first training data set. That data set would comprise the image. of your target object. And then you would have another training data set, at least in this claim, where you're then modifying these images using the first training data set. So for this one, you know, what's a little bit unique is you've got different data sets, and that can be common. You may be using the same data set. So those are the details you really want to think through as you're drafting your claim. Make sure that it's, you know, accurate. So if this claim recited a single training data set, you know, your competitor may be using 2 versus 1. So in this instance, I would actually write, you know, 1 or more training data sets so that you can cover 1 and 2, or 3 or 4, and etc. And then from that training data set in the claim here, you're then training the machine learning model to recognize the target object. Okay, next slide. Finally, the last type of claim is the architecture claim. Next slide. Again, more things to explain in your specification. You know, what are the architectural components? What does the invention do? How can the invention be applied? What is the technical effect? Generally, as Anna mentioned earlier, these types of applications, patents and claims, they tend to be a little bit less valuable. They're actually a little bit more rare. Most machine learning model, as I mentioned, it's not new. And you know, deep learning is kind of a challenging subject, but also with AI, you know, most of it's not new. It's been developed, especially you saw the trends in the graphs earlier. So, you know, in terms of novelty and non-obviousness, probably an easier hurdle to overcome. But in terms of subject matter eligibility, sometimes these claims can be seen as not being linked to a technical application. So as a result, it may be harder to overcome subject matter eligibility. And then, you know, sometimes also the claims, depending on how they're framed, can be considered broader. So, you know, you could have one single model that could be applied to 20 different applications. But it also could be considered narrower because there are several ways and several different models that you could use to, you know, be used on your application or to achieve a certain result. So it really does just depend on your invention. Think through the different kind of combinations, the different scopes in drafting your claims. So the last example is on the next slide. And this is an architecture claim, US Patent 11090997. This is a claim directed to a method for compressing an output word for a neural network model. So as you can see, there's several steps to this: mapping, dividing, obtaining, normalizing. It's really creating this neural network model. And for this one, if you Google the patent and look at the patent itself, they did actually a pretty good job putting in the technical solution that I talked about earlier. They talked a lot about how this great neural network, the problem was memory. And, you know, when you have a model, it may take up a lot of memory, may take up a lot of processing, but when you perform these steps like mapping, dividing, obtaining, etc., you're now faced with a computer that functions better. And as a result, you've got better memory and faster processing for this model. Next slide. So that's all that Ed and I had. We'll take any questions if anybody has any, but just generally, thank you so much.